I call the honourable member Michael Woodhouse.
Thank you, Mr Chairman, and I thank honourable members for their contributions so far. I think there have been a couple of issues raised that are worthy of addressing, and I think the first one I really have to address is probably the least charitable call I've heard in this House for a long time, and that was the Honourable David Parker. I really do think that it really is against the spirit of this debate and this bill to be quite so uncharitable about a bill which has very noble purpose. And I would accept something of a rebuke for the fact that the bill did have to be substantially amended, were it not for the fact that it came from the Honourable David Parker. And old and more experienced members will well remember, as I'm sure Dr Nick Smith will, that member bringing to the Committee of the Whole House in 2008 the Emissions Trading Renewable Preferences Bill with 785 amendments by SOP that went through absolutely no democratic process, completely rewriting that bill after 1,000 other amendments went in 2 days before the closure of submissions, completely re-engineering the bill. Now, he may well have a very good justification for that, but I will not accept the rebuke from that member on this bill. Now, he also talked very uncharitably about this being a worthless waste of money. Ms Curran, Mr Twyford also said, well, it does no harm, so we support it. Well, I think that lacks something, actually. If Labor thinks this is a worthless waste of time, they should actually have the courage, they should actually put their votes where their mouths are and vote against the bill. I would be quite happy to have that challenge laid down. I don't mind that. But if the bill, having gone through Select Committee under the very able Honourable Leanne Dalziel, recommended that the bill be passed, then let's stop talking about it as a worthless waste of time. And I think it's very helpful to look at the case for change. And it was somewhat well articulated by the Honourable Amy Adams. And I think it's also worth referencing the Charities Commission and the work that they did in 2008 to survey charitable givers.
Point of order, the Honourable Trevor Mallard.
Mr Chairman, I'd just like to draw your attention to the fact that there appear to be strangers in the House. We are currently on a member's bill, and there is not the provision on a member's bill for officials to be in the House. And there appear to be people sitting on the bench reserved for ministers' officials.
I will seek some advice on the issue. I think we'll carry on in the meantime while we are checking this out. I call the Honourable Minister.
Can't do that. You can't say I'm hopeless, I don't know, Mr Chairman. You've got to get a ruling.
Order. The issue is being checked. I'm advised that the member in charge of the bill is entitled to have officials. This is what I have.
Point of order,
Point of order, the Honourable Trevor Mallard.
A member in charge of a bill who is not a minister cannot have officials. Officials are government officials. They are not members' officials.
Thank you. I have been advised that members may have advisers. So I have been guided, and the situation is that members are allowed to have advisers. That's what we have.
Point of order, Mr.
Point of order.
Can I seek an assurance that these are the members' advisers and they are not departmental officials?
Speaking to that point,
speaking to the point of order, the honourable member.
I can assure the honourable member that they are advisers to me who happen to work for a government department, but they have provided advice, as they did to the committee.
Well,
Mr. Chairman.
Speaking to the point of order, the Honourable Nick Smith.
Mr. Chairman, I can speak to as a matter of record that during the Labor period of government, I had a member's bill with respect to the engineering profession, and exactly the place where the officials are sitting today with the Labor government's consent at the time, had sitting at exactly that place officials from the department as well as from the Institute of Professional Engineers, consistent with the standing orders. And what's taking place today is no different to what occurred during the period when Labor was the government.
Speaking to the point of order, the Right Honourable Winston Peters.
The trouble with that last submission you just heard was, and is, that if there was no objection raised at the time, it does not give it a status as a precedent in this House. And we need to know precisely who they work for now. And we have not heard that.
Thank you, Ms. Peters. I call the Honourable Member Chester Burrows.
Point of order. It appears to me, Mr. Chair, that you've ruled on this matter, and people seem to be taking issue with that ruling from their seat without getting to their feet.
Thank you. I've sought advice on it because I am not sure myself of the position with the officials who are sitting in the House.
Speaking to the point of order.
Speaking to the point of order.
Thank you, Mr. Chairman. I'm pleased to advise the House that the people providing advice to me are employees of the Ministry of Consumer Affairs. They have provided advice to the Commerce Select Committee in the 49th Parliament and will continue to advise the Minister of Consumer Affairs when the bill is passed into law as to the framing of the regulations.
Point of clarification.
Point of clarification, the Right Honourable Winston Peters.
The Minister and the Chair hasn't told us what we want to know. He's given some explanation.
Order.
Well, in your case it should be.
Order. Can I say to members on my right that when a point of order is being taken, it's heard in silence and there's no interjections whatsoever, and to the member, points of order are to be terse and to the point. Call the Right Honourable Winston Peters.
The first point I wish to make is, who are they employed by now? Not what advice they've given in the past, but as right now, who are they in the employ of? The Minister or a department?
Order.
Mr. Chair.
Order.
Speaking to the point of order.
Speaking to the point of order.
The Right Honourable Member did not raise a point of order and you shouldn't rule on it.
At the moment we're seeking some advice. I have...
This is the admittance of strangers. A person invited by a member is permitted to sit to the right.
Honourable Members, order. I have in front of me a situation regarding the admittance of strangers to the chamber, and it quite clearly states that to the right, a person invited by a member in charge of a member's bill, a local bill or a private bill, to advise that member on the bill. And in this case, that's what we have. It's covered under ancillary rules to the House. Well, no, but someone's going to make the rules. Point of order.
The member, Trevor Mallard, shouted twice from his seat asking you questions without asking to be called and not standing, and yet you seem to engage with him on that. Could we have some dignity in the House, please?
Thank you. Thank you. Thank you. This comes rules for admission to the chamber, lobbies and galleries of the House of Representatives during sittings of the House made by the Speaker pursuant to the standing orders of the House. That's where it comes from, and I'm assured that the people here sitting behind us have the right to be here. I call the Honourable Member Michael Woodhouse.
Thank you, Mr. Chairman, and that's a very timely reminder to thank the advisers who have given me, not only me, but firstly the Honourable Amy Adams in the initial stages of the bill, the Commerce Select Committee and now me, for the outstanding advice that they have provided and continue to provide. So I'm coming to that. Patience. I just firstly want to address the initial point, which was the case for change. And the Charities Commission conducted 2 surveys on public trust and confidence in charities. And in those, they noted, I quote, an increasing public concern over the fundraising techniques of charities and a reduction in confidence in the charities sector. And in particular, 34% of respondents in 2008 reported high levels of trust that charities ensure a reasonable proportion of donations get to the end cause, and that at least 38% of respondents agreed with the statement, quote, "Charities use more dubious fundraising techniques these days." And I think the Honourable Amy Adams gave us a couple of very compelling reasons why this legislation is very important. Now, Labor are free to decide what they do with that, but what I've heard in 2 previous calls is that it can't be in primary legislation and it shouldn't be in regulation. So what they're really saying is this can't be fixed. And yet this is a matter of very important public interest to those who give to charities. Now, I also want to touch on the issue that Mr Parker made, and I may have misheard him, but I thought I heard him say that the Fair Trading Act already provides for regulation powers in this respect. But in fact, that wasn't the advice of the Ministry of Consumer Affairs, who told the Commerce Committee that the Fair Trading Act would have to be amended to specifically allow for disclosure about third-party collectors, as Section 27(1) currently doesn't allow that. So there is definitely a need, there is definitely a public interest, and there is definitely an improvement to the environment in which people provide charitable giving. Now, to the question asked about whether or not there are draft regulations that have been made, and the answer is no, but they will be advanced over the next 12 months. The bill, right, just, if they will listen, they will get the right advice. They asked the question, Mr Chairman.
I call the Honourable Member Michael Woodhouse.
Thank you, Mr Chairman. They asked the question but don't seem to be prepared to listen for the answer. The bill provides for the Minister to consult, in fact requires the Minister to consult with affected parties before the regulations are drafted. No, that's not what it says. It says, and I'll provide the necessary position for the member, but it says somewhere in here that there is an obligation on the Minister to consult, albeit that Minister's failure to consult does not necessarily invalidate the regulation. Now, that's a way of framing regulations that is quite customary. It happened under the Labor government. I can't give you an immediate example, but that's quite a normal way of framing regulations. And in any event, I'm sure the Honourable Member Charles Chauvel will have something to say for that when it gets to the Regulations Review Committee. So, Mr Chairman, I want to look at, perhaps though, while we haven't drafted regulation yet, I have sought advice anticipating the question as to what the regulation might look like. And in fact, there are precedents around the world for the Ministry of Consumer Affairs in advising the Minister as to what that might be. Now, the UK model has what's known as a solicitation statement, which requires them to state the institution that they're fundraising for, if there's more than one charity, the names of those charities, how the fundraiser's remuneration in connection with the appeal is to be calculated, and the amount if it's known. In Australia, there are a variety of processes under regulation which are a bit different. In Victoria, collectors must disclose what they're paid to collect, so that's probably the intention that the member in introducing the bill had when she talked about the 20% and 50% thresholds. In New South Wales, collectors are simply prohibited from retaining more than 50% of the funds raised, and in Tasmania they use the term that the benefit cannot be manifestly excessive. So there's quite differing ways to do that. My own view, which will actually be up to the Minister of Consumer Affairs in any event, but my own view is that the UK model is probably the pathway that we should explore. I think it provides the comprehensive statement that we need, but it's not overly prescriptive, and indeed it talks about not being overly prescriptive. The last thing I just want to touch on in respect of the things that have been raised is the timeliness of this. And I have spoken with the Minister of Consumer Affairs. It is important that we don't let this drift. I think there is a high level of public interest, and he has indicated to me that he's quite willing to get advice on this in a timely manner, and that the regulation should be drafted and consulted on and passed into regulation in the next 12 months. And I thank the Minister for his commitment to doing that, because, as I say, this is very much a matter of public interest.
I call the Honourable Member